This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. Good Friday. And I'm Stuart Address. This is Ask a Lawyer. And for the next hour, we're going to chat a little bit about some legal issues. And you can take me off my script anytime you want by calling us at 340-1590. To begin, I have a couple of congratulations to offer. First, to the New York Mets. We are the spring training home of the Mets, and congratulations to the Mets on their 5-year anniversary of their first and only no-hitter. I remember 5 years ago tonight watching a game, inning by inning, thinking, no, it won't happen. We've lost it in the 8th inning. We've lost it with 2 outs in the 9th inning. Tom Seaver, my childhood hero. It's not going to happen. And it happened. Wow. So congratulations, folks. And if you're a little bit unhappy about the way the Mets are going right now, well, just think back 5 years ago to the no-hitter. The second is I have a little sidekick in the studio with me today. For the second time, I have my son, Aaron. And Aaron graduated from middle school yesterday at Lincoln Park Academy.
Oh, you're sending him to the big house next year.
That's right. The bigger house, the bigger building at Lincoln Park Academy.
Bigger kids.
Smaller.
That's right. And, I got to say, there are a couple things before we get into this, I love Lincoln Park Academy. The opportunities it provides are tremendous. Mm-hmm. It is a high school that is in the top 9% of the country of all high schools. I mean, think of that. There are 22,000 high schools in America. And according to 2018, Lincoln Park was around something like 900 or something. It was the top 9%. Mm-hmm. The opportunities that provides to a student who takes advantage of those opportunities during his 4 years in high school are extraordinary. And more so, I am hoping, it's a little tentative right now, but for any of you folks that may have students at Lincoln Park, I am hoping that come this August when they return to school, that we will be starting a speech and debate team, which I will coach. I have offered to coach. I have been in discussions with the principal, and they're excited about it. I had been chatting with them about it for 3 years since my son was in middle school.
You've been debating about it?
I've been debating about it for 3 years. Takes time to persuade and to prevail. My argument has always been that with Lincoln Park being such an extraordinary school with such opportunities, I couldn't imagine it not having what's called a forensics team, which is speech and debate. And so it looks like we may have one. So
Great.
If you got kids at Lincoln Park and you're interested in having them in speech or debate, we're going to probably start it out as a club and then hopefully not too long after, start going to some tournaments and just seeing how we do. You always start slow and you begin, but my personal view has always been that a class in public speaking should actually be required starting in elementary school. And in fact, in Broward County, I read, they have a debate team in all of their high schools, all of their middle schools, and a few of their elementary schools.
Wow.
They have 9,000 students involved in speech and debate. The Board of Education in Broward has a page for speech and debate on their website.
You would think debate would be a no-brainer for teenagers.
Well, right, they want to argue. So that's a great, I haven't thought of that.
Okay.
That is a great.
Use that.
I'm going to steal that. That is a great, if you want to argue, come on, join the debate team. Anyway, I've just felt it's always been very important. And the reason is when we get out of school, maybe we might not use trigonometry, not to offend any math people out there, but everybody's going to be engaged in public speaking one way or another. I'm doing it right now on the radio. If you want to go ask your boss for a raise, you're engaged in public speaking. If you need to call Comcast to complain, you're engaged in public speaking. One way or another, we all engage in public speaking. And the problem that I have found is so many people are afraid to speak even to a small group or even to one person. They're intimidated. And I just happen to believe this is my personal, vendetta. It's my personal mission in life. If speech was a required course all throughout the schooling process, through high school, I think you would get students coming out of high school that are more confident, more self-assured, who could communicate, and who, when they listen to stuff on MSNBC, CNN, Fox, whatever, they won't just take what they hear for gospel. They will have been trained to question it, to think about potential bias of who's speaking, what are their motives, and to look for evidence to the contrary. So that's my argument, folks. We'll move on to the real stuff now, but hopefully this is going to start in the fall. And if you do have any students or you have grandchildren or something that are going to Lincoln Park, let them know that there's probably going to be a speech and debate team come fall, and it's something wonderful. A very, very, very quick story. I did coach a high school team once while I was at Rutgers University. And it was a high school that had been perennially state champions, but then the program stopped. And it stopped for like over a decade for whatever reason. And I went to the principal and I said, look, I'm 5 miles away at Rutgers. Could I coach the debate team? And he said, yeah, sure, absolutely. They even paid me a little bit. Let me tell you, it was under $1,000. But they had to put me on the payroll.
Gas money.
Right, exactly. And I remember I had one kid that came into the first meeting, literally, who spoke with marbles in his mouth. You couldn't understand him. It was all mumbling. And he didn't want to just do one of the speech categories. He wanted to debate. That was a challenge.
Yeah. Did you tell him first you need to know how to talk?
Well, no, but we worked on his diction. We worked on him speaking more clearly. We worked on him enunciating. We worked on, you would do it with everybody, how it is you really have to listen to what's being said, think of your response, and be pulling out evidence. It used to be out of a card file, but now it's a laptop computer. And let me tell you, 6 months, 8 months later, they were in the novice state championships in New Jersey. It was incredible. And that kid, I don't remember his name. I don't even remember his face. I just remember it. That kid came to me not being able to speak to anybody. And
well, there's a lot of that today.
Didn't quite win the state championship, but was in the state championship with his 3 teammates.
Yeah.
Come on and join it. Anyway.
I say they need to speak open their mouths a little wider when they talk. I hear people on TV, they'll say their own name, and I don't know what they've said.
That's true. You hear it even on professional TV.
Yes.
Well, maybe if they had gone to speech and debate classes, even journalism classes, journalism where you have to ask questions like in the White House press room, you need to be able to speak. And you need to be able to get your point across succinctly and clearly, not like me who rambles on and on and on.
Well, you have a whole hour to kill.
Right. Well, I have a lot to say, and we'll never get through it in 1 hour. But, it's a passion in my heart that people learn to stand up for themselves, and they can't do that if they feel they can't communicate, they can't speak, that somebody's just going to overtalk them or out-argue them. And I have seen a little bit of confidence go a long way. So that's my pitch.
How do you feel about all this texting and less actual verbal communication?
Texting is wonderful for its own purposes. I use it a lot. It is not a substitute for verbal communication, and it is not the way to break up with somebody, which is apparently I'm understanding the in thing these days.
Okay.
I like shocks to my conscience that you can break up with somebody on a text, but no, texting, like any other technology, is abused. It has a great place in our society. Email, the whole thing, the written communications that go so quickly, but you have to be able to speak and state your position. And you want to know something? You even have to do that in relationships. And if you're too timid, there's a lot of bad things that can happen. So, let us just finish an area until questions come in. That means call us, please, at 340-1590. We were talking what you should expect from your attorney, what your attorney can expect from you, and we're going to really finish that up in a short period of time. In terms of what you should expect from your attorney, if you have a problem and you've gone for a second opinion to another attorney and you can't resolve it, just remember you can fire your attorney. You can file a bar grievance with the Florida Bar. Very simple. Go to the Florida Bar website. There's a link. Fill out the papers. Not very complicated. And the bar will investigate whether that attorney violated ethical rules. Now, that's the only thing the bar handles, ethical rules. So, that's an option for you too. If you have an argument about the fee that you're being charged, you could demand fee arbitration through the Florida Bar. If you as the client demands fee arbitration, the attorney must accept it. He has no choice. If an attorney asks for fee arbitration, the client could say, no, I'm going to deal with this in the courtroom. So there are a lot of options if you're having problems, and don't just give up. If you're having some problems, use the tools that are available to you, because that's what they're there for. Now, there are a lot of things that attorneys expect from their clients, and they're relatively simple, but a lot of times they fall by the wayside. Obviously, we expect you to be honest with us. And I've talked before, so I won't belabor it. But if I learn of something in the middle of a deposition or in the middle of a trial, it may embarrass me because I look like a fool, but it hurts you. It hurts your case. So you need to tell your lawyer whatever it is that needs to be told, whether it hurts, it doesn't hurt. Evaluate it, deal with it ahead of time.
Well, I would guess that if a client lied to you and you found out about a lie in court, how hard would you be working for me then?
Oh, I'll be working aggressively.
I mean, I would think you would have lost all faith.
It's too late. If I'm in trial, I'm going to do my darndest for you. Mm-hmm. I'm going to be aggressive. I'm going to be a pit bull. But the problem is, if what you didn't tell me is really significant, I don't have the time to try to remedy the damage, and I don't have the time to tell it first to the jury my way. And you hear it in the news all the time. I control the narrative. If you've let them control the narrative, you're already behind the eight ball. Mm-hmm. So, that's the problem. Now, we also can't do our job if you ignore our advice. Now, you're allowed to choose from different options, and you are allowed to ignore our advice. I mean, we're there for you. You're not there for us. But what I mean by you have to listen to our advice is on things that are not, case determinative. It's going to affect the entire outcome of a case. I advise you to settle. No, you don't have to listen to me. But if I'm advising you on something that needs to be done, I need you to get me your check stubs for the last 5 years, and I need them in 2 weeks. You need to listen to your lawyer. There's a reason that stuff is being asked for, and the delay has consequences. So, just a shorthand, when your lawyer asks you for something or gives you some advice, chances are you really should take it. We also, we just talked about this. We can't do our job if we're shocked at hearings or depositions or in trial. We have situations where if you don't tell your lawyer about prior convictions, that hurts. We might be able to deal with convictions if we know about them. So now my office routinely searches all our clients.
Just to make sure?
Even the ones that look like they can't possibly have done anything wrong. But yes, just to make sure. Because we have been surprised.
Mm-hmm.
The same thing goes for drug use. It may not be relevant even in the case, but they can ask about it at deposition.
Mm-hmm.
If there's a problem here and I know about it, I can coach you, which is proper, on how to handle those questions about past drug use. But if I don't know about it and you're surprised in the questioning that you're being under oath, you may not handle it very well. And then it becomes a problem. So let's just end that whole segment on what you should expect from your lawyer and what your lawyer should expect from you with sort of something very simple. The attorney-client relationship is a collaborative relationship. It is a relationship of cooperation. It's a relationship that requires reciprocal truth, and it's a relationship that requires the attorney to be available to the client and the client to be available to the attorney. If you have problems with the attorney, address them first with your attorney. Not all problems are sinister. If that doesn't resolve it, get a second opinion. Maybe that'll ease your concerns. And if that doesn't solve it, then fire your lawyer. All right, so the next thing we're going to talk to is about mediation and arbitration, what they're about, how they're similar, and how they're different.
Mm-hmm.
Sometimes when I tell a client we're going to go to mediation, they hear the word mediation, but they're thinking of an arbitration. And so I find that with most clients who have not been in court 5, 6, 7 times, I need to explain to them what I'm talking about, or you're going to have a miscommunication. So mediation. Mediation is voluntary. However, if you have a case in litigation in court, sometime prior to trial, it will become mandatory. The rules of our courts, and courts throughout the country now, they're getting there, every civil case in Florida has to go to mediation. Even small claims court we talked about. The first time you go there, they send you to an attorney to talk up and try to resolve the case. That's mediation.
Well, without mediation, wouldn't it take twice as long to get all the cases heard? I mean, wouldn't it be very burdensome on the system?
It's already very burdensome on the system, even with the statistics being that more than 90% of all civil cases settle before trial. Mm-hmm. The system is still incredibly overburdened. But mediation does offer an opportunity to settle it. It could be late mediation right before trial when the court's told you you need to go to mediation. Or it could be really early in the process before lots of time and effort and money have been put into the case, if it's an appropriate case for that. And you might be able to solve it early. I have one case right now. We are trying to schedule a early mediation before we even file the lawsuit. And I think it could resolve. If it does, it's to everybody's benefit. So mediation, what really happens? It's an opportunity. This is what all the mediators say. When you go to a mediation, all the mediators have what we call a spiel. Okay? They all have a story for a couple minutes that they tell everybody because they assume the clients have not really been experienced in mediation.
Mm-hmm.
And the spiel goes something like this. All right, you're here for mediation. I am not an arbitrator. I do not decide anything. I do not tell you who's right and who's wrong. My job is to help you cooperate with each other, negotiate, and try to come to a solution that both sides can accept, even if neither side loves it.
Now, who is this mediator?
It is an attorney.
Okay.
In Florida, you have to be certified to be a mediator. You can be certified by the circuit court to be a circuit court mediator, civil or family. You could be certified by the federal court, but you have to be a certified mediator.
Okay, but you're an attorney, but you're not an attorney for either side.
You're not an attorney for either side. Some mediators still actually practice law. Most mediators will tell you that they have stopped practicing law because if they represent generally plaintiffs, there's going to be a concern of mediation with the potential defendant that you're biased.
They're partial? Okay.
Yeah. So most of the really, really good mediators that I know, at least.
Now, who sets up the mediation as well? Is it set by the court?
The two attorneys.
Okay.
The attorneys. The attorneys are told when it's mandatory, at the stage of the case where it does become mandatory, or the attorneys decide on their own early on, let's pick a mediator. I may propose 3 people, they may propose 3 people. We talk about it, we agree upon a mediator. Then we contact the mediator, find out available dates, and mediation is set. It's that simple. So the 2 attorneys for the sides are involved in picking the mediator and coordinating it. Now, when you get there, as I said, the mediator's spiel. He says, I don't decide it. I'm here to help you. This is your opportunity to decide your own case. The alternative is you go to a jury trial and you have 6 people who you don't know who you're going to get, and they're going to decide your life in this case. And one of you is probably going to be pretty unhappy. So here's the opportunity for you both to come to some resolution where neither of you are thrilled, but both of you walk out. I won't say the word is necessarily satisfied, although I like to have my clients walk out very satisfied. But where the other side walks out not feeling they have been brutalized, but feeling, since they're usually the ones paying my clients money in my type of law, but feeling begrudgingly, well, at least it's over. That's what I want them to feel. If we try to get a complete and total victory, nuclear annihilation in mediation, they won't say yes.
Okay.
So mediation fails.
Right.
So I try to explain to my clients, mediation is not where you get $1 on your dollar. Mediation is where you compromise and you decide how much is it worth to have it over now, to have the money now, to not go through discovery, not go through motions, not go through depositions, not go through a trial, and then not know what's going to happen. Because as I've said on other shows, and I guarantee you, and I've heard this said at various seminars, every trial lawyer will tell you the same thing. We have lost cases we really thought we were going to win, and we have won cases we really thought we were going to lose. So you as a client say to me, how strong do you think my case is? And I tell you, let's say in this particular case, I think you have a really strong case. I think you got a solid case. I think, I can't guarantee you, but I really think we're going to win and, et cetera, et cetera. And then we lose. And the client turns to me and says, you told me I had a really good case. Well, now is where you end up debriefing yourself as to, well, what do you think went wrong? Sometimes there's an easy answer. They destroyed you on cross-examination. You contradicted yourself 10 times. You told them you had 2 felonies when you had 7. Most of the time, it's not so simple. Most of the time, until I really take a weekend or a week to think about it, because it sits in my head and won't leave me, most of the time on the courthouse hallway, I have to turn to those clients and say, I'm not sure. I don't know. I don't know what the jury was thinking. I don't know what their problem was. I'll talk to you on Monday.
But see, that's what it is. It's that outside opinion.
That's right. And sometimes on a 6-person jury, which is why historically we used to have 12-person juries in civil cases. Eventually the Supreme Court said, well, that's not constitutionally mandated. You can do 6. Now most civil juries are 6. Criminal juries are 12. I thought that was a horrible mistake, and that happened when I was in high school. group dynamics tell you things. Psychologists will tell you about group dynamics. When you have 12 people, it is unlikely that one or two people will control the group. Okay, the group will still have their own independent opinions and they will argue them. When you have 6 people, one person can rally the group. Mm-hmm. And that's dangerous in any situation.
It's that person who really wants to just get this over with and go home.
or for whatever reason completely disagrees with your version of the case. Mm-hmm. And now they start rallying around all these other people who agreed with you when they went into the jury room. And it can happen the opposite way too. So mediation is that opportunity to figure out a way to settle it on your own.
Now, what if someone doesn't show up for mediation?
Well, if it's a voluntary mediation, then they're just going to end up paying the mediator and no harm, no foul.
Okay.
If the court has ordered it, well, the court will probably sanction you, make you pay for the mediation, direct you to go to another mediation. And if you don't show up for that one, then if you're the plaintiff, your case is dismissed. And if you're the defendant, you've just lost, and now there's only a trial on damages. So before we finish that little part about mediation, we do have Eleanor on line 1. Hi, Eleanor. How can I help you?
Hi. I just wanted to mention that in our case, all parties had to pay for the mediator. That's very important.
Yes.
Yes.
That is true.
I just wanted people to know that.
Absolutely. I completely agree. Typically, each party pays their share. If it's 2 parties, it's 50-50. If it's 3 parties, it's a third. When I'm the plaintiff, very often the very last thing I will say to the mediator when the other side is trying to get me to say yes to the last offer is, yes, if they pay all the mediator's fees. And very often that's what happens. But you're right. You do start out with it being split. And thank you for the call, Eleanor. I appreciate it. So anyway, now, how does it work? So you have this, you all get together initially in a conference room. And yes, sometimes you don't all want to see the other side, but with few exceptions, and I've had a few exceptions, with few exceptions, you all start out together in a conference room. And then we, instead of talking about what happens in that conference room,
hold that thought.
We take Terry from Port St. Lucie on line 2. Hi, Terry. How can I help you?
Oh, good morning. Thank you for being there. This question may be kind of complicated. Maybe it's not for a lawyer, but we'll see how it goes.
Let's try it.
Okay. This is what happened. My friend has a boat parked in his yard. His neighbor was out spraying her fence. She was going to spray her fence, and my friend said to her, make sure you don't get that. It's a stain. That
right.
stain on my boat. It was a windy day, and lo and behold, he came home from church that morning, and there was a note on the door. Hi, sorry I got some paint on your boat. Tried to wash it off, but I couldn't get it to come off. So his boat was totally sprayed. I'm talking the panel where all the switches are. So it's a mess. So he finally found someone that can repay it. Well, he first had a survey man come that surveys boats. Yeah, okay. So he gave him the whole survey and what it would cost and all that sort of thing.
Okay.
And then he finally found someone, a nice young man, to do the boat. Now he's working on it, almost finished. So how do we go about this? Her insurance should pay for it.
Okay. Have you talked to her? Has she agreed to pay for it, first of all?
Well, he went over and told her she had to pay for it. I mean, that she said her insurance would pay for it. That's
okay. Well, you can put a claim in through her insurance company. Hopefully, it's an act that is covered under her homeowner's policy, and you get paid, and hopefully the insurance company offers the amount of money that it took to repaint the boat. If not, then you may have a legal problem. But in general, given the situation you've described, that neighbor is responsible for the damage to the boat.
Right.
There's really very little question about that. The only question is what it's going to take to get it paid.
that's my question, because the young man that's doing the boat is going to want some money. He has had to buy various products to remove the stain that's on there. And my friend is willing to pay him, but I said to him, which he should do, but I said, maybe you should have got we don't have the insurance, her insurance. Do we contact them ourselves?
Well, if your neighbor is cooperative, she should file a claim with her own insurance company.
Well, she's not. I mean,
all right, then
over there.
do you know her? Do you know who her insurance company is?
No, we don't even know.
All right.
She's going to have to tell us, but she's just no. He went over there the other day to ask her something about a product that she used, and he wanted to get the information for the young man that was cleaning the boat. And he knocked at the door, and she said, "What do you want? I gave you my phone number." That's how.
All right, let me tell you what it sounds like. It sounds like your neighbor is not really going to be cooperative. Short of filing an actual lawsuit, the best thing would be to go to a lawyer to send her a demand letter and a demand for her insurance information, so that you or /lawyer can then contact her insurance company and make a claim if she's not willing to do it herself. But it doesn't sound like you're going to be able to get anywhere with her, because if she won't pay it, if she won't cooperate, if she won't give you the insurance company information, there's no way to make that claim and have anybody pay for it. So I think your next step probably is either, a lawyer of your choice, or you can call my office and we can try to coordinate, having you come in for a consultation and, figuring out what it would take to do a demand letter, so that hopefully she gets a lawyer letter now and it has a different reaction. And maybe she files a claim with her insurance company, or at least we get the insurance company information so that, we can do it for you, or you can do it for yourself.
Okay. Well, this is the first time I've listened to you. How long have you been on the radio?
Oh, about 4 months, I think it is, give or take.
Well, I haven't been and I'm back on track now.
Well, that's good. I'm glad to hear it.
I listen to the radio, this station, all the time. So, what is your name and where are you located?
My name is Stuart Address, and yes, the last name really is Address.
Really?
Yes, it is. And my office is in Stuart, believe it or not.
So Stuart Address has a Stuart Address.
You just took the sentence out of my mouth.
I'm sorry.
You walked on my line.
I'm sorry.
You're fired.
I guess I wouldn't forget.
Most people don't forget that. It's on US 1 in Stuart, just over the Roosevelt Bridge. And my office number is 781-8003. And if you call there, even now, you'll get a lovely paralegal named Cheryl, who will be happy to take all the basic information. She's probably she's listening. So she's probably heard the story already. So she can get a little bit more information, and we can see what happens on Monday.
Awesome. And that's why she's so wonderful, because she's listening, right?
She's listening because if I don't mention her name at least once when I get back to the office on Monday, she says, "You didn't even say anything about me."
Okay. You need to do that. And Stuart. It is Stuart. Okay.
Yes.
Stuart Little. Okay.
That's right.
Yes.
But I'm very big.
You're very big. Well, that's okay. I have, I took my mom to a doctor. Anyway, his name was Dr. Minnie. But he was not Minnie. He was a large man, a wonderful man.
That's right, you see?
So funny. So I like big men, so that's a good thing.
All right, so give us a call, and we'll see if we can help you.
Great. Thank you. Thanks for the radio show. I listen every day.
That's wonderful. We're every Friday at 10:05.
Oh, just see what I mean? Friday. Okay.
All right.
I'm almost back on track. Good. Take care.
You take care. You're welcome. Bye-bye.
So before you even started your Ask a Lawyer program, when we first got the information about Stuart Address, who had a Stuart Address, we were cracking those jokes before we even met you.
I don't blame you. I think it would be very natural. The funny thing is, not only am I Stuart Address that has a Stuart Address, but my late father's name is Martin, and it's Martin County.
Oh, my goodness. It was like destined, right?
It would have been weird.
Destined to live there.
It would have been weird if my office was on Goldie Lane, because that's my mother's name. That's right. So, again, we're at that conference table in mediation all together for probably about a half hour. So if you really don't like the other side, don't freak out too much. Your attorney is with you. They're on the other side of the conference table. Their attorney's with them. Mediator's at the end. Mediator tells his little spiel, that this is your chance, and that, he's not going to make any decisions. He's just going to help you. And then both attorneys give their little talk for, 10 minutes or so. If you're my client and we're the plaintiff, we're asking for money, the other attorney is probably going to look right at you and try to scare the living, what out of you.
So is it attorney to attorney while you sit there and
right?
attorney?
The clients generally don't talk in that open public session.
Okay.
Now, they can, and the mediator will tend to ask, does anybody else want to say anything? Most attorneys have instructed their clients during this open session, don't say a word.
Okay.
Mm-hmm. You can tell the mediator everything you want in our private sessions. So, but as the other attorney on the other side, when I'm the plaintiff, for the most part, they're going to try to intimidate you as to all the things that can happen that are wrong with your case. And I always tell you, you look at them with a stone face. If you play poker, you know what I mean. Nothing matters to you. Nothing they say affects you. You don't want to let anything on. So now, before I tell you what happens when we leave that conference room table, we have Dennis on line 2. Hi, Dennis. How can I help you?
Hey, good morning. I have a question.
Sure.
A friend of mine just went to mediation, and he and his relative worked out a deal. And it's his son. It's a real estate deal, and he's not abiding by the arbitration. Now what happens?
All right. Now, was it a mediation or an arbitration?
Okay. Mediation.
Okay. The mediation agreement can be enforced in court. If you have to, you can file an action in court for enforcement of the mediation agreement, and a judge will order that it be abided by, and there are sanctions that are available. Contempt of court is one of them. If you don't abide by those, and making the other side pay the attorney's fees for having to go to court to enforce the settlement agreement, all those things, the filing fee. Short of that, like I usually say to most people, a lawyer writing a letter to him saying, this is what's going to happen to you if you don't comply, hopefully solves the problem. But if not, then you're left with a motion to enforce the settlement agreement.
Okay. And would you have to have an attorney to pursue that, or?
It really depends upon the nature of the mediation agreement. If you're talking about, a small amount of money, not really. If you're talking about anything of any significance, if you're talking about anything where you have to get into circuit court as opposed to small claims court or even county court, circuit court is anything over $15,000, you need a lawyer.
Well, this is real estate, so it's...
Yeah. I mean, there are too many pitfalls for a non-lawyer to step into and to lose a case that should be won or lose a motion that should be won. So, yes, I would say you need a lawyer.
Oh, okay. I'll pass this along.
All right.
I appreciate it. You have
Not
a
a problem. You too. Take care.
Yeah, thank you. Bye-bye.
Bye-bye. So now we have all said our little piece. One side or the other is going to go to another room. And so now we have what's called shuttle diplomacy. The mediator will shuttle from room to room to room to room, sometimes as much as a dozen times. And he'll try to get the plaintiff to come down with their demand, and he'll try to get the defendant to go up. And where we end up, nobody really knows because everybody bluffs. And your attorneys sort of know the way of the game, and I usually tell my clients, look, don't worry about the first offer they make you, and don't even worry about the second offer. By the third round, if we're not being serious, we'll know it. The idea is to get them talking. So, mediator, it's funny the way it works, really. I mean, all my mediations. The mediator is typically with me and my client very briefly in each round. Because I know what I want. My client has certain things, in different rounds that they want to communicate to the mediator to help support our position. And I tell them, with the mediator, feel free. It's your case, talk. Say what you want to say. Say what you feel you need to say to try to reach an agreement. And, the mediator will tell you, anything you tell me is confidential unless you tell me I can communicate it. So sometimes you tell the mediator something so he or she understands. but you don't want the other side to know. And sometimes you do. You want
Because you want
messages-
that person to know where you're coming
right.
from.
And sometimes you do. You want the message passed along. So they'll do that. So then they go to the other side, and I pull out my laptop. I start looking at my email. I may play some games on my laptop. I may call my mother, Mom, if you're listening. And why am I saying all that?
Mm-hmm.
Because the mediator is usually in my mediations with the other side an hour and a quarter before we ever see him again. It's like, what are they doing in there?
Yeah, they went out to lunch.
Well, okay, here's the reality. He's in there now with the side that has to pay money. That's a lot harder than being with me asking for money. Because with me, he's saying, okay, now come down a bit. They've made this offer. Now, you know, sometimes I'll come to a number. He'll say, I don't really think that's going to work. Or, you know, give me at least this number. Sometimes I'll do what he asks. Sometimes I'll say no. It all depends upon the actual case and the mediator. How much faith I really have in that mediator. And they go back and forth, and we try to get closer. And sometimes there are non-monetary provisions that we argue back and forth on. But now let's take it near to the end. We get, mediator comes back and says, this is their best offer. They say, that's it, last offer. And I turn to my client and I say, don't have to believe that. I never believe it till I hear it at least twice, sometimes 3 times. Because it usually is not really the last offer. So I tell him, okay, well, go back and tell him this. And we see what happens. Sometimes now they move, and that's their best offer. And I give them another number, and we play the game. Okay, let's say now we're really at the end. And I believe we have extracted everything we're really going to extract from the other side in a mediation without a trial. Now, by now, you have already probably made the decision with me on whether we're going to accept that number. We've already been talking about it 3 rounds ago. Okay, we know where our end number is. So usually I don't really even have to turn to you and say, is that okay? Because you told me while the mediator was out the last time. But, all right, we're at that last number. I really do believe that this is the best we're going to get. So, I look at you and I say, is it a deal? If it's a deal, we put it on paper. We get the bullet points down, subject to the attorneys later on drafting a much longer agreement.
More
everybody,
paper.
Right, more
Yeah,
paper.
yeah. A thicker file.
But we at least get the bullet points on paper and signed by everybody. So it's an enforceable deal. And if you turn to me and you say, no, I may have told you I think you should say no. I may have told you I think you should say yes. And we've discussed it. And your answer is still no. Okay. Well, then I turn to the mediator and I say, go back and tell them that unless they're willing to pay this, that's it. We are walking out. And I start putting everything into my briefcase, and I'm packing up my laptop. And I say, this should take 5 seconds, not an hour. I mean, it's either yes or no. That's it. Sometimes it's funny. They are the ones that blink all of a sudden. And I have to open everything up again. And sometimes it's just, mediator says, I'm sorry, but you don't have a deal, at least not today. Maybe tomorrow, maybe on Monday. People have a chance to think, but not today. And that's the way it goes. So nobody will ever force you to say yes at mediation. But mediation is truly a great opportunity. I think especially if you're on my side of the table most of the time, which is the plaintiff's side asking for money. Because if you can get an amount of money that you believe is fair, not necessarily what you may be entitled to by a jury that believes everything you say and gets really angry about what happened, but that you believe is fair, then you can settle it now, walk away, be done with your own lawyer, be done with the legal system, and move on with your life. So as we conclude the concept of mediation, we have a very famous guest to come with us for a question. We have Mr. Bulldog on line 1.
Hello, Stuart. How are you?
Hello, Bulldog.
Hey, Stuart, I wanted to ask you about that mediation. You know, I wanted just a little clarification on that because it would figure that it would be an outside lawyer that is not associated with the client nor the prosecution.
Correct.
But you know, kept mentioning that you were going back to the client and advising, and should it not be that you don't have direct client access?
No, they're with me. They're with me the whole time. The client's with me the whole time in that separate room that when we break out. What I'm talking about is the conversations I have with the client when the mediator is in the other room, and sometimes the conversations I have with the client when the mediator is with us as to what should our next number be, how much should we go down, where are we looking to end up.
Have you ever been a mediator?
Actually, no, because I'm not certified.
Oh, really? I didn't know that was a...
Yes, you must be a certified mediator under the Florida rules of court, either state court or federal court. I have quite literally thought about it over the last couple of years, taking the class, and you got to take a big class, and then you got to sit as a secondary mediator in a mediation, like 10 mediations with another mediator. And then you've got to be the mediator where that other mediator watches you do it and steps in only if you're about to destroy the process. So it's a process. I think I would enjoy mediation on that end of the table.
I think you should go for it, sir. I'm going for a doctorate, so I think you ought to go for what you go for.
Well, maybe I can be a mediator. Mediators make really good money, and I've often thought it would be a lot less stressful to be on that side of the table.
Yeah, it kind of would be better to have both sides pay you, right?
Both sides pay you, and look, whatever they decide, they decide.
Yeah, but get off the money, man. It's all about job satisfaction.
You're right.
As to what you want to do. It's not about the money, man.
As a mediator, you get to go home and not worry about these clients.
Right.
You've done your job.
See where I'm going with that, right?
I do. The evolution from a solo law practice to a mediation practice.
I'm just throwing it out there.
Well,
man,
I appreciate the career advice. I've thought about it.
All right. Well, you take care, sir.
You too, Bulldog.
Have a great day.
Thank you very much. Well, that really is a good idea, folks. I've often thought about being a mediator of my own. Sometimes I wonder, though, who would use me, because I'm not the kind of guy in town that everybody loves. You know, I have people that think I'm good. I have people that despise me. So, I'm not so sure if I'd get enough clients to be a mediator. That's, I rock the boat. I have plenty of attorneys on the other side where I have the most professional and cordial of relationships, even when we're battling. I mean, and I got to tell you honestly now, after 33 years, with a little bit of more experience, and a little bit more age and wisdom, I much prefer it. It's much more pleasurable to deal with somebody on a professional basis, even if you're adversaries. You don't have the venom, coming through. Then the client, the attorney on the other side, where we're yelling and screaming on the telephone. We start yelling and screaming in a courtroom and a judge has to tell us to be quiet. It's like, a Worldwide Wrestling Federation or something like that. It's, tag team. I can do it. I used to have a lot of fun doing it. I can still do it. I sort of enjoy doing it at times. But it's not my preferred method anymore.
But it's there if you need it.
It's there if I need it, and I need it often enough that, there's a big statue in my conference room from Disney, a big statue of Grumpy. And I look to my clients, that's me. I'm grumpy. And, if the other side wants to poke the bear will react. And my button's bigger than their button. I promise you. And if anybody doesn't know what I'm talking about, you're not listening to the news. So we only have a couple of minutes, so we won't talk about arbitration right now. except to say in a sentence that the essential difference between mediation and arbitration is the arbitrator acts as a judge. The judge, he hears the evidence from both sides. You're together in that room. And at the end, he makes a decision. And that decision is binding. Whether it's a private arbitrator that you pick, whether it's an arbitrator from what's called the AAA, the American Arbitration Association.
Now, are they attorneys as well?
They, for the most part, they used to be.
Okay.
They don't have to be. They could be somebody that is experienced in that particular industry that the dispute is about.
Okay.
And they, have to be an arbitrator. But their decision is final.
Mm-hmm.
And you can take an arbitrator's decision to court to get a judgment to enforce it if necessary. And there are so few bases to overturn an arbitrator's decision. Well, we can talk more about that next week, but essentially, unless you're going to show that arbitrator had real bias or was somehow affiliated with one side or the other or something like that, something really, really bad, that arbitrator's decision is binding. You don't get another bite at the apple in court.
So who decides mediation or arbitration?
Well, a lot of contracts have arbitration as a condition. It's a clause.
Okay.
You have an arbitration clause. You got to live with it. Even if you didn't like it when you signed it, you didn't have a choice. It's an employment contract. Tough luck. You signed it.
Right.
Now, if you don't have one of those things, your attorney can say to you, look, the court's going to take 2 years. If you want, we can suggest arbitration.
Okay.
And the other side might say yes, might say no. You can do it that way. But as we wind down, let me just say I thank you for your calls. I appreciate the calls. I enjoy them. I hope you all have a really good weekend, and I hope it doesn't rain. And, maybe in honor of the Mets no-hitter, go take in a St. Lucie Mets game. I'm Stuart Address, and my office number is 781-8003. Thank you for listening, and I'll talk to you next week.